Okay, we are calling the case of Department of Health versus the United States Navy. This is docket number 21-UST-EA-02. This is the final status and pre-hearing conference. May I please have appearances? Is anyone appearances, please?
Hearings Officer Day, I do not see Mr. Hargrove.
Oh, that is true.
I have his direct line. I can text him right now.
Okay, that would be great. Thank you. Okay, we're going to go off the record. Okay, we're back on the record. Once again, this is docket number 21-UST-EA-02, Department of Health versus the United States Navy. This is the final status pre-hearing conference. May I please have appearances of counsel beginning with the Department of Health? Mr. Hargrove, I believe you were muted. Yeah.
Good morning, everyone. Thank you. Good morning, everyone. This is Wade Hargrove, Deputy Attorney General for the Department of Health.
Thank you. Mr. Jensen.
Good morning, everybody. This is Craig Jensen, representing the Department of the Navy. Also with me today in this room are David Fitzpatrick, and on the virtual system are Marnie Riddle and John McKay, all three also representing the Department of the Navy.
Thank you. Let's go with Sierra Club.
Good morning, David Henkin of Earth Justice, and with me today virtually is Kylie Wager-Cruz, also of Earth Justice, on behalf of proposed intervener Sierra Club.
Thank you very much. Last but not least, Board of Water Supply.
Good morning, everyone. This is Ella Foley-Gannon of Morgan, Lewis & Bockius. With me this morning virtually is David Brown, also of Morgan, Lewis & Bockius, and Jeff Lau of the City and County of Honolulu. And we are representing proposed intervener Board of Water Supply. Thank
you very much. First of all, let me just thank everybody for the for conducting the meet and confer yesterday, and also providing me with that very helpful summary, which I think we should go over in just a little bit, just to confirm where we're at, and also where we might have any disagreements. Before we proceed, I just had a few matters I wanted to take up. I thought maybe we just begin by associating Jonathan McKay and Marnie Riddle. I just wanted to make sure that we're doing this correctly. First of all, does anyone have any objections to the association of these two attorneys?
No objections from Sierra Club.
No objection.
Okay, Matt, Mr. McKay. Let's pull this up.
Yes, good morning.
Okay, just one moment. Apologize. Okay. Mr. McKay, where are you licensed to practice law?
I'm admitted in the state of Massachusetts.
And are you in good standing?
Yes, sir.
And you are not a resident of the state of Hawaii?
No, I am not.
You regularly conduct business in the state of Hawaii?
No, but I am admitted in the companion case Pro Hoc Vice for the contested permit hearing.
Understood. Do you agree to be bound by the Hawaii rules of professional conduct with respect to this proceeding?
I do.
Thank you. Ms. Riddle?
Yes. Hi.
Hi. You are a member of the highest courts, bar of the highest court in what state?
California, sir.
And you are in good standing?
I am.
And you are not a resident of the state of Hawaii?
I am not.
And you do not regularly conduct business in the state of Hawaii?
That's correct.
And do you agree to be bound by the Hawaii rules of professional conduct for purposes of this proceeding?
I do.
Thanks. Thank you. I'll just ask all three attorneys, I don't know when you began your work on this proceeding. Is there a date which you would like me to make this order retroactive to?
For this proceeding, I would say the date that the original order was issued.
Okay, understood.
And the same for me.
I will issue an order, but for all intents and purposes, you are admitted, pardon me, you are associated for purposes of this hearing to the local counsel that is listed on the caption that you filed yesterday. So an order will follow.
And hearing officer Day, assuming if we are admitted, then Dave Brown and I will also have to be associated as we are licensed in California.
Okay, let's do that. I didn't even think of that. Okay.
Yeah.
So let's do that now. Any objection?
None from the Navy.
None from Sierra Club.
Yeah, and just to get that verbal objection from the Department of Health. Thank you.
Understood. And you are associated with Mr. Lau, I assume?
That's correct.
Okay. So Ms. Gannon, you are a member of the California Bar,
I am.
and you are in good standing?
I am.
You are not a resident of the state of Hawaii,
I am not.
and you do not regularly conduct business in the state of Hawaii.
I do not.
And you agree to be bound by the Hawaii rules of professional conduct for purposes of this proceeding?
I do.
Thank you. Mr. Brown, you are licensed in the state of California?
I am.
You are in good standing?
I am.
Okay. And you are not a resident of the state of Hawaii?
I am not.
And you do not regularly conduct business in the state of Hawaii?
I do not.
Okay. You agree to be bound by the Hawaii rules of professional conduct for purposes of this proceeding?
I do.
Maybe we make this retroactive to the date of your filing, which I believe was Tuesday?
That's fine.
Okay, order will follow, but for all intents and purposes, you are associated for purposes of this proceeding with Mr. Lau.
Thank you.
Second order of business is we are going to be sending out a docket. We've been working hard on creating kind of an official docket of this case where you can access the dockets or the documents that have been filed with file stamps, and that would be the official record of this case. The way that we've done this is basically anything that has a caption on it is getting filed. It's going to be in the docket. With respect to kind of more of the informal emails, basically the only email, I think, besides ones that have been attached to, for instance, an order, would be the one I think that was issued by me on Monday, postponing the evidentiary hearing. I would appreciate it when this gets sent out to the council. If anyone thinks that there's anything wrong with the docket, as in either there's something missing or for whatever reason the document didn't get uploaded correctly, please let us know immediately and then we'll endeavor to correct it. But that would be something that is a database that you can access and that will be updated continuously. Any questions about that? Okay. Okay, let's speak about the the hearing now. Once again, I appreciate you guys meeting and conferring. Now, I suppose maybe I can share my screen and we can just kind of go through this this document. Let me pull this up. Share my screen. Is my screen being shared?
It is.
Yeah.
Okay, so this was the document that was submitted yesterday. Once again, I thought it was very good. So let's just go through this. With respect to the transmission of pre-hearing filings, could perhaps Department of Health explain exactly how this is going to work and how these documents will be transmitted to the hearings officer by 12 o'clock on Saturday? Deputy Hargrove? I'm going to ask you to unmute. Thanks.
I apologize. Could you repeat that question?
So we're going through the document right now, which is what we're dealing with is the transmission of pre-hearing filings. I just want to make sure, because when I read this, I was still a little confused about how this is going to work. It says right here, DOH will attempt to create one subfolder each for each party for uploading documents, and that it would then be emailed. I guess it's just maybe in just summarizing exactly what that means and how it would work.
Yeah, and thank you for the question. And I, again, apologize for the delay. I'm
No problem. No problem.
going to get better at finding that unmute button. Not used to having one. The idea was that the parties during the conference expressed some concern about document organization. I think we all shared that concern. How could we most easily find those documents that we filed and that others filed without having to sort through the entire, if it's just a list of documents or if it's just a file and it's just document names, it would be more difficult to locate the one you're looking for if you didn't know which party it was affiliated with. Given the fact that we came up with very early on an agreement as to the way in which the files would be labeled, and that's the DBSN nomenclature system with the numbering, we all also agreed that that would most likely resolve the issue as much as need be, but still felt it would be helpful if the main file could be broken down into subfiles for each party so that the party downloading or I should say uploading the document into the main file could upload their document into their subfile.
Okay. I understand.
Yeah, just as a matter of organization. And we thought also it may assist the hearings officer, you locate the document you're looking for. So it was really just an idea associated with the organization of the main folder.
Okay, understood. Okay, and so basically, you guys will work that out on your side and everything will get uploaded, and then somebody will just send everything, the whole database by 12 o'clock tomorrow. Is that correct?
Well, again, what we were hoping is that this file that's being created could have those subfolders so that each party could upload their documents to that subfolder. If that's not, from an IT point of view, if that's not possible, then needless to say, we're all just going to dump our documents into the main folder, and then they'll of course be labeled appropriately, so they will be organized that way or organizable that way. But yeah, the hope was that, and I know you're receiving some assistance on this IT component, if there could be the main folder for the hearing, which everyone will have access to, and within that main folder have a subfolder for each party then each party could just populate that one folder that is theirs as opposed to it just going into that main folder. Again, it was just an effort to increase the level of organization. And I'll just give everyone a moment. Is that a correct or fair summation of what that discussion was about and what the purpose of the subfolders was? Not.
Yeah, if I could just add, yeah, I think that's generally accurate. And I think Hearings Officer Day, that we were hoping that the that uploading into that shared file would be filing and service.
Okay, so would we get it? So basically, if you provide us with the link, like even just like now, we'll check it as of 12 o'clock, and that would be it. Is that correct?
I think that was the idea.
Okay.
So because we even for many parties receiving the filings from Board of Water Supply, which were voluminous, there were a lot of glitches in the timely receipt of those things. So I believe that DOH should propose to provide that link to the parties, I believe by sometime today, so that we could do a test uploading to make sure that no one has any difficulty. That's why it also provides for perhaps the Navy providing a backup if there is any difficulty, particularly for the Navy. They anticipate their system might not interface with DOH, but in any event, we would all, like for example, we were intending to upload our motion to intervene files, which are not voluminous, but more than a single piece of paper, and see how that works today. And then that would give us some confidence that it would be up there on noon tomorrow, and everyone would be able to download at noon tomorrow, rather than having hours of back and forth trying to get the pleadings.
Okay, I understand. Just basically, I would just say, just keep me updated on what's going on. If you have any problems, please let me know. We'll try to see how we can figure out if you need any of my assistance. Otherwise, just try to get it to us any way we can, and that would be sufficient. Anything else on transmission of pre-hearing filings? And then we'll just quickly.
Dave, this is Stella.
Yes.
I'm still not exactly clear, because we have created a folder with all of the pleadings that we intend to give access to everyone on this call, as well as their identified staff and from the staff's emails. But I think that is not contemplating all of the other, like the exhibits that are going to be due by 12 noon tomorrow. So that part, I'm not clear as to whether DOH is working on that separately, or whether we will be assuming that.
Well, so basically my kind of view on this is that the exhibits being transferred, and anyone tell me if I'm mistaken, the exhibits being transferred are going to be viewable by all parties and by us. They're ultimately not going to become a part of the record until they're admitted into evidence. And then so basically, once they're admitted, we'll have an exhibit list, which we can then check the boxes as to what's been admitted. And then after the fact, then upload them to our docket to make them part of the official record. Does anyone disagree with that? Stella, did that answer your question?
Yes, thank you.
Okay. Any other thing? Oh, go ahead.
That question was helpful to me, because I had understood from Stella's or Ms. Cam's email that was the system to which we would upload, and now I understand it is not. So I want to confirm with Mr. Hargrove that he's working on another system that we're going to receive information on, a link to, for the upload of exhibits. Over.
Yeah, and I think I would ask for clarification from Ms. Cam. If that's something that we need to further coordinate with someone with department's communications, we can do that. There's a program specialist within the department with whom I've communicated the need to do this. And it was my understanding. So I clearly I'm informed. It was my understanding that she had already reached out to you, Ms. Cam, and that there was going to be some effort made to get IST to set that up. But if that's not the case, I can do that now.
Okay,
Okay, so there is crossed wire. There are crossed wires. Okay.
yes.
Okay. Stella,
I would
think
just add that.
oh, go ahead.
Sorry, I was just going to add that, the idea is that, the hearings office, should have the possession of this, right? It shouldn't be my client, the Department of Health, right? So that it remains this independent actor, if you will. But it obviously just so happens that it's one Department of Health, and so I do know that there are folks that can help create this. And so, needless to say, unless anyone else has a different thought, I can get on this with Miss Cam right after the call.
Let's do that. Let's do that.
Together.
Okay, I appreciate that. Stella, does that work for you?
Yes, although I'm thinking, should the IT folks be talking to each other as well as to me? Because we've got our IT, and then you've got the DOH IT, and I'm not all that tech savvy, so.
Okay. I guess Ms. Cam, you know what we need is basically a folder with then 4 subfolders that these individuals have access to that they can drop their stuff into. I think in my mind, it seems relatively easy to set up. But let's just work that. Let's try to work that out, and we'll do that promptly after the call. Does that work?
Sounds good.
Okay, thank you very much. And thank you very much. Sorry for the confusion, everybody. We will try to work this out, and we'll be in touch about making sure this goes smoothly, or smoother than it has so far. Anything else on the transmission of pre-hearing filings at this time?
If I may, just to clarify, so I think the shared understanding is that whatever locus we upload our files to by noon tomorrow, that will be service and filing, correct? Is that
correct? So let's just say that for some reason this idea falls apart. We'll have to do something else. Everyone's going to have to just figure it out. We'll let you know as soon as possible. Hopefully it'll work out.
Thank you.
Okay. I'm going to share my screen again. Let's see here. Okay. Can you see my? Oh, here we go. Can you see my screen? Okay.
I'm sorry, Hearings Officer Day. I'm just also anticipating, given the potential volume of exhibits, that if everyone's trying to upload at 11:50 a.m. tomorrow, I can anticipate the possibility of some logjam. So I guess it seems to me that it might be helpful to have one forum for uploading things that are not exhibits, everything else, which will be less voluminous, and one for exhibits.
I was thinking that with respect to everything that's not an exhibit, that could just be emailed to everybody, because I don't think those are going to be voluminous. Am I correct?
I wouldn't anticipate that they would be.
Yeah, so I think that actually email would be best, because then that is immediately brought to our attention. I think that exhibits, it makes sense to upload because they're just too big to even, our emails won't be able to take them. But as for everything else, I think that just with every other brief that's been filed or every other submission, email has been sufficient.
And Hearing Officer Day, just to confirm, the universe of that everything should be most probably any pre-hearing briefs, any exhibit lists, any witness lists. And I can't think of anything else right now. So I'm just asking if someone else has an idea of what else.
I was going to raise the issue just real quick. I think any declarations that of direct testimony.
Hearing Officer Day, I had anticipated including those as exhibits and
okay.
filing. And
that's
filing
fine.
that.
That's fine.
Okay.
I think either or.
I'd like to suggest that the declarations of direct testimony also be emailed, because that will not, presumably that won't be voluminous in terms of how many megabytes it is. And again, I'm anticipating there's going to be some logjam on the actual uploading of exhibits, and we're going to need to review those direct testimony to prepare for Monday, and et cetera.
Okay, so why don't we do this? Mr. Jensen, I think anyone can add anything to their exhibits, but with respect to declarations for direct testimony, even if you upload it to your exhibits, I think that everyone would appreciate it if those are also emailed, because those are obviously the things that one of the many things, but one of the main things that everybody would want to be able to review thoroughly, and so that could just be highlighted and be easily accessible for everyone. I think everybody would appreciate that.
Understood.
Okay, thank you. Anything else on the transmission?
Just real quickly, Hearings Officer Day, while so that this can be, so that folks can get to work on this promptly, is there anyone that Ms. Cam would have the IT folks that I had been working with get in touch with in particular for her? I mean, with respect to the creation of this file. There are folks that I'm working with that I thought were kind of
Dave,
maybe.
Dave, you're sharing screen still
Oh,
through your email.
I didn't mean to close that. I was trying to close my my screen. Thank you very much for letting me know. Stop
Sure.
share. Stop share. Sorry.
Wade, we are working, or I'm working with Brandon Salbedo in AGIT.
So why don't I do this just while, before we move on, I will take a moment while still participating in this call to get those two folks in touch. And the person that I'm working with is named Tu Perry. And I don't know, actually, maybe I will have them get into email contact with each other so they can start working out the logistics. Because as I believe as Mr. Hinken represented earlier, we definitely want to try and do a test run, drop something today, later today, to make sure that the technology works and the file set up properly, because we'll have to come up with a backup plan if it doesn't work. And I know that Mr. Jensen has offered Department of Defense option that we probably don't want to resort to if we don't have to. So let me get that. It's Brandon.
Salbado.
Hang on.
Okay.
His
Salbedo.
email. Yeah, Salbedo. So his email is Brandon, BRANDON .A as in apple dot Salbedo. It's SALB as in boy, ED as in day, O at Hawaiʻi.gov.
Okay.
And also Brandon, I think between Tu and Brandon, they might need direction as to which agency is going to be setting this up. And so perhaps, Dave, we need to make that determination, I think.
We can do it.
So you're thinking Brandon will take the lead?
If we can do it, we can do it, because I'm fine with that.
Okay, so I will email Brandon and tell him that we're taking the lead on this.
Okay. All right, sounds good.
Wade and Stella, I don't want to overcomplicate things, but I'm thinking that since only exhibits will be uploaded and they'll all be named with our naming conventions, then maybe no need to make subfolders if that will speed up the process for your IT folks.
Department of the Navy would request subfolders.
We'll see. I think that we'll do our best to do it according to what you guys had agreed to. And if there's a problem, we'll let you know. Anything else on this? I'm sorry, this is kind of taking long, but I'm glad that we're able to work this out because apparently we weren't on the same page. Okay, I'm going to share my screen again. So with respect to exhibits, obviously, I think that this is great. The naming convention. This, it seems like there was a disagreement, and I wasn't exactly sure what this meant. Why don't I begin with the Navy, because it seemed like the Navy was the one that was in disagreement. Maybe I'm wrong.
No, you're not wrong, Harry Day. And actually, it was the Navy that started this conversation. So the representation to you is inverted from how the conversation actually occurred at the meeting confer yesterday. What the Navy was trying to do was reach, I think, what is your goal in creating a manageable record. And it's very clear from the interveners with regard to their motion to intervene, and also with regard to representations today from Mr. Henkel that yes, that there's going to be a significant amount of permit hearing documents included within their exhibits. So I was looking for a framework that would make it something digestible for you, given the limited time frame you have to make your decision. It was clear from the conversation that my proposal was rejected, and no framework on that point was possible. And so I just provided that data point for you at the lower half of the paragraph for information. We're not going to be able to do that. So in turn, Department of Health and the proposed interveners offered up, as you read here in the first sentence of the paragraph, that for purpose of cross-examination, all documents will be deemed admitted or deemed admissible, subject to objections regarding relevance. I took a look at that. The first point I made to them, and I'll make here again, is that runs counter to the idea of creating a manageable record. It just basically opens up the record even more, despite Hawaii statute rules with regard 9110 in particular with regard to limiting consideration of immaterial and repetitious evidence. But I don't generally have a concern with regard to what exhibits from the permitting hearing will come in. The rules are fairly relaxed. Yes, there's a relevance objection. Yes, there's a materiality and repetition objection, but I don't anticipate that the Navy will be lodging those objections over the weekend. I'm not willing to enter into a stipulation for that. I just recognize that with rules of evidence relaxed and with the intent of the proposed interveners clear, assuming that they do intervene, this will be a very hefty record for you to consider, sir. Over.
Thank you. Would anyone else like to speak with us? Why don't I begin with the Department of Health? If you have any comments, you don't have to. You're on mute.
Yep, no comment other than just the observation that yes, I think we all should share some responsibility for making it a record that is as targeted as it can be to the issues material to your decision making. Everything is it's an emergency order. Department's interest is in you reaching a well-reasoned decision as quickly as possible. So
thank you.
Not an objection to any particular exhibit or to any of the interests of the interveners in increasing the volume of the record, but again, hoping that everyone can target their submissions in a way that furthers a kind of an express purpose rather than just the enlargement.
All right, I appreciate it. Thank you. Sierra Club?
Well, I think that everyone shares the desire to make sure that you can make a decision on an expedited basis. I actually think that the proposal that Sierra Club, Board of Water Supply and Department of Health had agreed to was actually to encourage people to submit less in terms of their initial round of exhibits, so that they would just submit what they needed in terms of their case in chief. And then just to have the assurance that if they needed some other document from the other permitting proceeding, to cross-examine a witness and not as part of their case in chief, they wouldn't run into an objection other than on the grounds of relevance. So it was meant to be narrowly tailored, and the desire was to reduce the belts and suspenders approach that attorneys very often take to throw everything into their case in chief so they're not precluded from raising it later. So that was the nature of it, but I'll defer to Board of Water Supply, who had, I think, more extensive thoughts on this.
Thank you very much. Board of Water Supply.
I agree with Mr. Hargrove and Mr. Henkin. The desire is to make sure that we will have access and that you will be able to have access to the relevant documents during the proceeding. And that we will be able to, point you to, assuming that we are in a party to this, that we will point you to things that we think are critical to your decision making. And so that's, we're not trying to put the kitchen sink in, but we do think that there are really critical documents out there. And then, when we resolve this issue, we do have another issue just about the sort of the numbering of the documents that I would like to raise, but we can pause here so you can consider this issue.
Okay. I'll just kind of give my general thoughts about this issue, about just generally the volume of documents in general. Is that I don't want, especially at this stage, to say that anyone can't submit anything, right? I think that if someone thinks that it's appropriate for their case, then so be it. I will say that if we're dealing with particularly if we're dealing with a large record, I am going to be relying upon the parties, especially in their proposed findings of fact and conclusions of law, to identify what aspect of the document is germane. I don't anticipate that I will just read everything and then just come up with my own conclusions based on what is in a document if it's not otherwise cited. In that respect, even if the record is large, I'm going to be relying upon the parties to make it manageable for me to use. But I'm not going to make any statement about what anyone can or cannot file at this time. I just don't think that would be appropriate. I leave that to the discretion of the parties and then proposed interveners. Does anyone else have any comments right now on the paragraph which we just discussed? And then I understand that Ms. Gannon wants to maybe move back to the numbering. I'm going to share my screen again. So now we're going back, I believe, to this paragraph.
Yes, it's related to that. It's just that most of the documents that we will be submitting, or many of the documents, are things that we also used in the other contested case proceeding. So we already have them date stamped with a B- number. So we wanted to raise the issue and say, would anybody object if we had non-consecutive numbering? So that if there are documents that we will not use in this proceeding, we may have some numbers that are missing, but they're already date stamped. So it would be a lot of work to have to redo that. And so we just wanted to see if that would be acceptable to the parties.
Navy will not object.
Sierra Club?
We don't object. We just observed that if they were date stamped electronically, it's pretty easy to run a new series, but we don't object.
Mr. Hargrove?
No objection from the department. Thank you.
Okay. I think that I was just going to observe that I think that that's why the exhibit list is important, to the extent that so it's just the bait stamping, or is it the exhibit number itself?
It's the exhibit number as well.
Okay, that's why I think as long as the exhibit list is clear as to what is an exhibit and is not. I mean, in trials, there's frequently gaps as we're going. So I don't think that there's anything inherently unusual about that. So I'm fine with that.
Thank you. I appreciate it.
One clarifying question is, Gannon. On your exhibit list, will you include a range of date stamps for the documents? We'll know that there's not missing pages.
We will.
Thank you.
Anything else on that?
No, thank you.
Okay. Lastly, I appreciate this. I don't think this requires any. So this regards the objections to the admissibility of exhibits. I think that that's a great idea, and I appreciate that, and I'll just adopt that. So by 12 o'clock tomorrow, or no, pardon me, objections will be communicated to other parties and the proposed interveners by email. No later than noon on December 19th, which I believe is Sunday. Is that right? Okay. And could those also be served upon the hearings officer? Is there any reason why that would be?
No reason it could not, sir.
Okay. Okay, so let's do that. Okay, anticipated witnesses in lieu of direct testimony. I would like to just, I thought that this was excellent, or I think excellent in terms of expediting the proceeding. I just wanted to know what was meant by the phrase limited live direct testimony. If anyone wants to volunteer and kind of explain what that means.
From the Department of the Navy's perspective, the intent is to put the witness on the stand and have them authenticate their declaration and submit the declaration into evidence, and then have them testify as to the more significant pieces of the information within the declaration, given the limited amount of time that we have to conduct the hearing.
Okay, excellent. Does anyone disagree with that? And so I think that this is fine. And this is noon on December 18th, which is again Saturday. And I think anything agreed to here seems fine. With respect to stipulated facts, that's, I mean, it's okay. I think to the extent that there are, I'll just add this, is there going to be duplication of exhibits? And do you anticipate where like there'll be multiple copies of the same exhibits in the same?
Yes, sir, we talked about that, and that's unavoidable given the exigencies of the hearing schedule. We're just going to have exhibits that we're going to mark with our numerology, and the opposing counsel will do the same.
Okay. Do you think, is it possible if at the hearing, and I'm just throwing this out there, I mean, because what I think I'd like to avoid is having multiple, I mean, I don't see any reason why multiple copies of the same document should be admitted into evidence. You know, I guess to the extent, is there any reason that we can avoid that? Or any reason why we can't avoid that? Let me ask that.
It's, again, the scheduling, sir. We don't have the time to work that out.
Well,
I guess to respond, if hearings officer Dave, you're suggesting that at the hearing, we could all agree that, let's say, exhibit N1 is the same as exhibit B12, which is the same as S33, and we only need to admit one of them. And then as far as, I guess all that would mean is whoever wasn't lucky enough to get their exhibit in might need to adjust their bait stamp page references in their findings of fact, conclusions of law. Is that the thought?
I don't want to make this hard. That's because if it's going to be hard, then we'll just do what we can. I think it might be helpful then if at some point, if we do just kind of admit everything in bulk, then that basically there'd be some sort of agreement or stipulation as to which documents are the same. Do you think that would be possible?
Yes.
Okay. Navy?
When would we have this agreement, sir? Before the hearing, during the hearing, after the hearing?
I don't think it has to be during the hearing, as long as everybody knows what's going on. So, because I know that you guys have a lot to do to prepare. So, you know, we can talk about that after. I think it would be helpful, perhaps, at least by the time that the findings of fact and conclusions of law are served.
I have to change my flight again.
Let's see here. I'm going to share my screen one more time. Okay, with respect to opening and closings, I think this sounds fine. Order of presentation, if it's agreed to, sounds fine. Time allotment, I appreciate. And we intend to do this. We do intend to do this. We need to find somebody who will be able to run the stopwatch, but we do intend to do that.
During hearings officer day, I did, there's one thing I inadvertently omitted from what we agreed to yesterday, which was that for purposes of closing arguments, the order of presentation would be inverted. So it would be Navy, Sierra Club, BWS, and then DOH.
Inverted. Okay. So basically just literally flipped around. Okay. Does anyone disagree with that?
Maybe does not.
No, that's accurate. Thank you. Kylie,
okay.
for putting this together. That was greatly appreciated.
Yeah, this is excellent. With respect to, I am absolutely fine with this. And I really do appreciate you guys agreeing to do that. And so I am going to be in contact with the Department of Health staff to ensure that we can do that. I'll let you know if that is somehow impossible. I don't think, given the exigencies of this case, that that should be a problem. But we'll have to confirm. With respect to, and this is just kind of like a related matter, with respect to lunch or a break, I anticipate that it wouldn't be more than an hour. It might, depending on how we're going, it might be 45 minutes. I just suggest, this is just a suggestion, just bring a lunch that you don't have to go out and get, just so that in case we're kind of moving slow, we can kind of do it short lunch. That would be my only suggestion. Nothing fine. And then I absolutely appreciate this last one, stipulated protective order. So basically my understanding, if I may ask Mr. Jensen, is that there will be no protected non-classified information that will be submitted in an exhibit. Is that correct?
Correct, sir. We're going to dumb our demonstrative exhibits down so that there's no controlled unclassified.
Okay, thank you very much. Okay, I gotta stop sharing my screen. I'm just trying to think if there was anything else. Before we leave the document that was filed yesterday regarding the summary, does anyone else have any additional comments regarding anything that was addressed in the summary?
I have one other question, hearing officer day. Is there going to be is the public going to have access through a Zoom to this hearing?
No. So what they're going to have access to is through YouTube, and so that's in the hearing notice that notice that went out. And so basically, the links that we're going to be sending to you, and we're going to, and this is one of the next things I'm going to be speaking about. We're going to need your emails for your witnesses and anyone who is going to need access to the Zoom hearing, because it's going to be a closed Zoom hearing insofar as no one, not just anybody with the link is going to be able to jump on. They're going to need to be authorized to do so. So basically what we'll just need is the email address of anybody who's going to be signing in to the proceeding. And so I believe that should answer your question. The public at large will not be able to come in and
Got it.
Dave, and I also confirmed with DOH that that the witnesses will need to have Zoom accounts also. Okay.
Okay. So please ensure that any witnesses that you will be calling will have Zoom accounts.
That's going to be difficult for us. So just to clarify, so normally Earth Justice has a Zoom account, and so when we need to talk to folks, including our witnesses, we just send them a link and they can click on and they can join without having their own account. Am I understanding correctly that they need to get an account? If so, do they need to get a paid account in order to be able to stay in the hearing long enough? What are we requiring?
I don't know the answer to that. Stella, do you know the answer to that? Sorry, I thought this was easy. I didn't realize that it might be a problem.
I was
think-
able to join via the browser. I cannot download this account on my system here, so they shouldn't have any problems joining with the same link that I received today.
Stella,
Okay.
can we confirm?
Yeah, I think when I talked with the DOH person who's setting up the Zoom link, he was saying that if they have a Zoom account, then he can identify them and place them in the waiting room. So I'm not sure whether just the email address will allow. I think he can do that, but I'll need to confirm with him if he has a list of the email addresses of the witnesses that he can identify them and place them in the waiting rooms.
Yeah.
If I might suggest, since there will be a witness list, and if there are going to be waiting rooms for the witnesses to be parked until it's their time, then there could be some screening that would happen. Again, some of our witnesses, in fact, maybe all of our witnesses, I wouldn't guarantee they have a Zoom account. They're not that type of person. So.
Understood. Stella, let's talk to the IT after and make sure that that we can do this properly so that we're not scrambling on the day. But I do understand what you're saying, and I don't want to cause any problems. We will work on that. But if in the meantime you could send us the email addresses of the of your witnesses. May I ask, for instance, Sierra Club, will you have a party representative that will be attending?
Yes, we will. And, we're still in the process of finalizing our witness list in our situation that we often are dealing with citizens. We need to find people who are available during a workday, and also people who are, to be candid, willing to testify publicly against the Navy. So that's why our disclosures will happen by noon tomorrow. Obviously, they have to happen then, and that would be the time when we could provide a finalized list of email addresses.
Okay. I would just say, just for our purposes, if you could also just sometime before the hearing, just identify. Well, actually, it probably doesn't matter. You could just identify anyone who has a party representative who's going to be there. Just make sure that we know so that they can be admitted into the Zoom room and be available. Otherwise, we will be sequestering witnesses into their Zoom rooms. And then I guess it would be appropriate for them to. Does anyone disagree that it would be appropriate for us to order witnesses not view it on YouTube separately? Because basically, we're not going to be allowing them to be in the room and watching. That they should not also be watching on YouTube. Does anyone object to that?
So just so I'm clear, so if our witness would also be our party representative, if they're designated as a witness, they can't attend the hearing?
No. If they, this is all right. So let's just back up. Party every entity is entitled to one party representative if they so choose.
Right.
And that party representative can be in the room and watch the hearing. That party representative can also testify, but every party is just entitled to one. And besides that, everybody else will be sequestered. Does anyone disagree with that?
Well, Mr. Day and to the rest of you all would present a question. I'm trying to get through some material in an allotted amount of time. My witnesses are all state of Hawaii Department of Health employees. They have been working collaboratively on the Red Hill project from the beginning. Are there any objections to having, and again, this is just in the interest of efficiency, and so there are fewer opportunities for glitch or delay. Is there any objection to, and what we're talking about here is a witness exclusionary rule, which I think there's a question as to what degree, if any, it applies in this situation anyway, but given that it's an administrative hearing and it's concerning scientific, technical data and analysis that's collaborative in nature, but at any rate, just putting that out there, in other words, it's not a hit and run case. The question I have for everyone is there an objection to my having my client who all work in the same building be invited into a room where there's a setup for the interface with Zoom, and one person comes in, does their bit, leaves the room, the other person comes in. Is there a reason so that there is one link, if you will, for the department's witness, and I just exchange them in and out of the room, no one else in the room? Is that objection?
I'm going to offer up that was the Navy's intent also. I'm sitting at a computer that's not an MCI enabled so that it can be used for this link. And this is where I will be on Monday. And then separately in a room, a building over, are going to be the witnesses, or the room where the witnesses will come in and do their testimony, one at a time, obviously. And with Mr. Fitzpatrick will be in that room with the witness and no one else. So that's my intent with regard to how the Navy's case would go.
And just to add some additional context, that is in fact how I have presented at hearings, administrative hearings, and these are administrative enforcement hearings, not unlike this one, not necessarily emergent in nature, but in the past, for context. And that's simply, by the way, that's simply due to the fact that the department's resources, that is what they have. They have a video conference room. It's set up for this purpose. And so I feel a lot more comfortable that having that one link and that one setup, it's far less likely to be interrupted by switching between witnesses in different locations.
I'll just say I have no problem with that. If anyone else has a problem with that, actually, so for that purpose, then all we would need is an email address that would allow us to, Zoom that, so that one Zoom account could then link up.
Right.
So I don't
think it simplifies things.
It does simplify things in my mind. Does anyone have any problem with that? That sounds reasonable to me.
No concerns. I did want to clarify that one of my witnesses will be testifying from DC. So obviously he will not come here to get into that small room.
Understood. And that sounds fine. So just before we go any further, Mr. Hargrove raised an issue regarding the witness exclusion rule and whether it applies. I just kind of assumed that we were going to do it just because I guess my background is litigation. Do people think it applies? Navy?
Well,
You want it to apply.
Whether it applies or not, and I haven't looked into that, I can offer up that Navy goes last. So to the extent that the other my party opponents or my opponents want to have their witnesses observe the testimony of the other witnesses, to include my own, which would be last. I don't know that having them do that would have any impact on the Department of the Navy's case, and therefore I would have no objection to them watching the case via the YouTube link.
Okay. Mr. Hargrove, I guess you suggested that it shouldn't apply.
Well, I think what I was suggesting is that, to be honest about it, I had not looked into whether it does apply or not, whether there is any precedent for that. I think we honor the spirit of it in any event. In my past experience, we just honor that the spirit of that rule. Since generally speaking, as we've all acknowledged, the rules of evidence don't apply to administrative hearings. I think there's a question in my own mind as to whether it's entirely appropriate But then in any event, my witnesses, it's just not a problem. And I say that because with respect to my witnesses, whom I'm most concerned about, obviously, they are presenting material about which they all are extraordinarily comfortable speaking individually or as a whole. Why? Because they've all participated in the production of that body of evidence. It's not, it's really would be impossible for any one of my witnesses to speak on anything that I'll be presenting without the other witnesses already being arguably at least familiar with the material, if not more. So it's one of those situations where it just is a practical, I was really speaking just as a practical matter. None of my witnesses are going to gain any benefit from hearing the testimony of their colleagues. But I'm not taking a legal position on whether it should or shouldn't.
I understand.
Right, just trying to figure out what we can all be comfortable with, given that we can reach an agreement by virtue of the rules of practice and procedure with respect to how the procedure would.
So if Mr. Henkin or Ms. Gannon want to say something, that's fine. I just will say that I feel more comfortable with it, just in case something comes up. I just want to be in a position where, you know, for instance, I mean, I'm not saying there is rebuttal or something like that, but if someone for whatever reason says, you know, we're entitled to it, I don't want to be in a position, well, they watch the proceeding. So I think that just to kind of protect the integrity, my strong inclination is just to continue with that. Mr. Henkin, Mr. Lau, or Ms. Gannon, do you disagree?
We agree.
The board's fine with that.
Okay. All right. So what we'll do is when you're speaking with your witnesses beforehand, just note that, you know, even though there is a YouTube available not to watch, unless obviously they're in the party or they're a party representative and in the room. You know, otherwise they're going to be in a waiting room where they can't, you know, watch until they're admitted. So just direct them with respect to that.
On a related point, I think that the Sierra Club's witnesses may be different than, at least some of the Sierra Club's witnesses are going to be in a different category than the others, and they're not employees of any of the parties. They're that sort of thing. You know, what I've been informing them that we will be able to give them a little advance warning via text or whatever when they're likely to need to join, because folks have to work or have other obligations during the day on a Monday. I assume that's that we can work with that, and hopefully I would just ask everyone is because Sierra Club would, assuming we're admitted, and assuming Board of Water Supply is admitted, we would be up third, and so there's a lot of variability in terms of when that would happen, but we'll try and forecast a little bit during the breaks between the parties so we can notify our witnesses, and I hope that there'll be some indulgence if we have a little difficulty reaching someone.
I'll just say that I understand, obviously, just everyone should try to endeavor to do their absolute best so that when it's your turn, that you're ready to go. If for some reason there is an issue, obviously raise it. We will try to be reasonable because I understand.
Thank you. And they will all be calling, everyone's going to be calling in separately. So we don't have a centralized room.
Okay. So that way we will need to work out exactly how we're going to do that, and email addresses, and we'll talk with the IT and give clarification on that.
Thank you.
The only, as I see it, as I understand it, besides, I will issue an order mostly, and I appreciate that this summary was given to me in doc form, as I can now use it. It'll just probably deal with mostly the scheduling aspects. I'm going to not include everything, but I will just say the one thing that's pending, as I understand it, is the motions to intervene, and the ops are due this evening, or I guess this night. Just so that for my planning purposes, and this is, I'm not going to hold the Navy to this at all. Just asking Mr. Jensen if you know approximately when the ops might be filed in this.
It will be well before midnight.
Yeah, I'm glad. I'm glad for your sake and for mine. Your sake and for mine. Okay, thank you very much.
It will be by close of business, sir.
Okay, thank you very much. Again, my intention is as soon as I can, and I've made a decision to issue a brief minute order, just to give certainty. I think that one of my jobs in this is because of the fast moving nature of this, that whenever I can give certainty, I will. And so I will endeavor to do that as soon as I can. Other than that, does anyone believe that there is anything that I am not doing or that I should be doing or that's pending that I haven't mentioned?
I would like to note for the record and assume everyone saw it, but perhaps there was someone who didn't, that yesterday in response to your restated and supplemental disclosure, Mr. Hearing Officer Day, I did submit a response that did not object under 11 Tech 1 Tech 25 to your participation as the hearings officer, but did instead renew the objection I had with regard to the removal of former hearing officer Jacobson. Yes, Mr. Jacobson. This is an objection that I put on the record at a staff conference before the motions to intervene were filed. So my friends Sierra Club and Board of Water Supply were not able to hear that objection and your response. I decided, since I had the opportunity, to put it on the record in written form for purposes of preserving the record, as we're not getting a transcript of the hearings themselves. I just wanted to renew my objection, recognizing that you've already ruled on it, sir. And I wanted to put that on the record in case someone had perhaps not seen that part of my response to your disclosure, sir.
Yeah. And thank you very much. And just for clarification, I'll also just clarify for the record that, you know, I put out an order just saying that there had been no objection to my participation in the case. The issue that you raised is not that issue. And so it wasn't subject to the deadline. And so, you know, it's not in any way affected by my order on that. So it is on the record.
Thank you, sir.
I have one final technical question, if I may, which is whether there will be some sort of tech support line that attorneys and their witnesses can contact if there are technical issues, especially given that a lot of us have really slim teams to be handling a hearing and the technical issues that may arise.
Stella, do you know, would it be one of our guys? Would it be DOH?
I think because DOH is assisting us with the Zoom proceeding, I will talk with the DOH representative who's helping us directly with the Zoom hearing that day and ask if they are able to make another person available for any emergency type questions on Monday from attorneys or witnesses. And I will, after talking to the DOH person, if I can get a name and an email and a contact number from them, then I will circulate that to all of the attorneys.
Okay, thank you. Anything else at this time? Okay. Hearing none. So we'll close this again. I'll issue an order just relating to what has been discussed today. I'll issue an order regarding the Association of Council. I believe probably today, probably relatively soon, I think we'll be sharing the official docket. We will be in contact, or I should say, Stella will be in contact with, I believe, DOH, or with Wade and DOH regarding how we're going to do this exhibit thing, which I think is the one kind of outstanding issue of significance. And so we'll do that immediately. Other than that, this time, I am, if anyone has an issue over the weekend that needs to be addressed, I personally will be available basically at any time, obviously not when I'm sleeping, but I will be monitoring my emails. So if something does arise of significance that you'd like to raise with me, please do so. Or I should say, feel free to do so. Mr. Hargrove.
Just wanted to maybe while we have the opportunity, get some additional clarity on a test run. I think that we all have great interest in performing this afternoon. So maybe if Ms. Cam, once you've confirmed that we're good to go, if you'll send an email to the parties council so that we can each, obviously it's of no significance what it is, but a PDF that's maybe more than a face page, so that we can see if it works. I'll nominate a thing that's already going to be in there so that it's, save yourself a step. I'll certainly be doing that, something that I'm already intend to put in there. But if that's agreeable to everyone, and I don't know, Mr. Day, how you feel about that. Does that sound like,
Yeah.
We just want to make sure it works today?
So I'm going to tell, so this is what I think, and this is the easiest way. If we can go on an, so one of the thing that makes this complicated is these permissions, right? About who can access which file, right? If we can have some sort of honor system where I just give you the thing and we can just say, I'm ordering everybody, don't only upload things in your folder, don't touch anybody else's folder. If everyone can live with that, it would be very simple. Otherwise, I could do that right now. But if it's otherwise, it's going to be a tech thing. Can people live with that or not?
I don't understand the proposal, sir. I thought the purpose behind having a repository with multiple folders is for all parties to be able to gain access to see not just their exhibits, but everyone else's exhibits.
So there's ways that there's, for instance, permissions that say that only, for instance, the Navy can edit this folder, even though other people may view it. So basically, that's what I'm saying. We're all professionals here. If it could be said that basically you only add things to your folder and no one else's, I can make that I know how to make that myself, I think, like right now. So if
Yes.
everyone is there any objection to that?
No objection. So we will only upload to our own folder, but I believe what Mr. Jensen's referring to is that we want to be able to download from someone else's folder.
Anyone can download from anybody. Only parties you can't manipulate anything. You can't add anything to anybody else's. You can't delete anything from anybody else's.
I would just observe that Mr. Henkin therefore is going to have to send my birthday card a different way.
I already sent it by email, so you should check.
Okay. All right, I'll put that in the order. I literally think I can do that myself. And then you can just test it out. Okay.
And just to clarify, for purposes of today's test, Sierra Club's intent is to upload a document, probably our motion to intervene, that we have already filed in the case. So it's big enough so we can see if there's a problem and there's no issues, So anyhow, we're not intending to upload something prospective.
Okay. So let me, so actually I will do it. I'm going to talk to my tech guy, but I will do it myself. I'm going to do this because I think I know how to do it. So I will work on that and then submit to council.
Thank you.
Anything else? Okay. Thank you very much. I look forward to reading submissions. And I will just say for the record, my goal and what I intend to do is no matter what, any direct testimony that's submitted, I will read it. That's going to be something so that you don't have to doubt that I will have read that testimony. That's going to be the number one thing. Otherwise, thank you very much. Appreciate it. See you guys on Monday. Okay, we're off the record.
All right, then happy birthday, Craig.
Happy birthday, Craig.